Hi everyone, thank you so much for joining me. Today we are going to be talking about the latest immigration news and updates. There are some major things that you need to be aware of if you are going to be filing any applications with USCIS, okay? This is a major change in how USCIS is going to handle cases that they deny, so you really want to pay attention. The first thing you need to know is that there's a new policy in place for USCIS to basically refer as many cases as possible to immigration court. Okay, so typically, if your green card application is not approved, you may end up in immigration court. But most times, USCIS just leaves it as is, right? They don't go ahead and put you in immigration court. They leave you alone. But with this new policy, they are encouraged, right? Now, USCIS is encouraged to put people in immigration court. So, to give every single case that they deny a removal, a deportation filing, right? So, you go from having your case denied with USCIS, and now you end up in immigration court proceedings. That is the latest um, news, and I wanted to bring that to you as soon as possible because that just happened this week. Right? We get so many updates. I can basically go live every single day with all the craziness, but this is one that I wanted to share with you all because I know we talk a lot about applying for green cards, applying for citizenships, all of those things. We talk about them. I tell you how to do it, what things you need to be aware of before you file, all those things, right? We talk about that a lot. But now, with this new policy in place and recommendation for USCIS to basically become right an enforcement agency. For most people, USCIS is the good guys when it comes to US immigration because you go to them to apply for your green card, your citizenship, to apply for your family, things like that. So they're seen as the good guys. And ICE is seen as the bad guys because they issue the notice to appear for immigration court, they put people in deportation proceedings, and they deport people. Now, USCIS is going to take on that enforcement role. So they're going to go from being the place you go to apply for benefits to now not only can you go there to apply for benefits, you can also end up in immigration court proceedings because you applied for benefits. So it is becoming not so much um, a happy place, but it's going to turn into another arm of ICE moving forward. So, wanted to get that in there. If you have questions, please feel free to put them in the comments. Okay, I am here to help as much as possible, so please ask me your questions. Hi, Frederick on Instagram, and hi, Mohammed. Thank you so much for joining me. Humanity First says immigration is human rights. Um, yeah, so-called anti-immigrants are possessed by. Okay, so yes, immigration is human rights. Felipe, hi, welcome. Thank you so much for joining me. Feel free to say hi. Feel free to ask me questions. This is literally breaking news that we're getting on my end, so I wanted to make sure that you know it as well. So, all right. Question from Mohammed. Can my wife file for an I-130 with a green card within the US? So, with a green card holder can file for their spouse, which is an I-130. But if the spouse is physically in the US, they cannot get the green card itself, right? They can do an I-130, definitely. They can do an I-130. The question is, can the spouse, if they're physically in the US, actually get a green card? The answer to that depends on if that spouse that needs the green card is in valid status. If they are not currently with an immigration status, if they overstayed a visa, if they entered with parole, anything other than they have a status that's still ongoing, the green card holder spouse can file an I-130 for them, but the person that needs the green card cannot file a green card application because they are out of status. They have to wait for that spouse to get their citizenship, and then they can adjust in the US. The other option is to basically to get their visa from outside of the US. But if they already overstayed a visa, depending on how long they overstayed, they may need a waiver in order to actually get that visa outside of the US. So it does get complex when the spouse is a green card holder versus a US citizen. So you can start the I-130, but my recommendation most of the time is that figure out how soon the green card holder can get their citizenship and apply for citizenship as soon as possible. Okay, but you can start the I-130. All right, so big news coming out of USCIS with their policy updates is that when you file, let's say, a green card application based on marriage, and it goes through processing, you go to an interview, and then they make a final decision, and that final decision determines that either your marriage is not real or you don't qualify for a green card, and they deny your case. At that stage, once they deny your case, USCIS now has the option to decide, okay, we denied this case, we're going to refer this person to immigration court. We're going to issue a notice to appear for them, which means that the person now goes from applying for a green card with USCIS to basically fighting a deportation in immigration court. So it is now going to be normal for USCIS to do this when they deny a case. One thing to note is that USCIS has always had the right to do this. Okay, this is not a brand new thing, right? USCIS has always had the right to put someone in immigration court proceedings. The only difference here is they are encouraged to do it, right? Like I said, with previous administrations, they will process the application, and if they deny it, they deny it. They typically would not immediately put the person in immigration court proceedings. With this current administration, they are basically making USCIS put people in deportation proceedings because they can, right? Because they have the right to do it, they're using every single avenue available to them, right? They're using every single way possible to put people in deportation proceedings. So do not take it lightly when you have to file a green card application, when you have an interview. Every single step that you take from now on your applications matter. Okay? Don't take the fact that you have an interview for granted. Be prepared for your interview. All right? Be prepared, because the interview, I am telling you right now, they're going to be scheduling almost everyone for an interview, and that interview is going to make all the difference, right? So you need to be prepared for the interview. And I have seen cases that look great on paper fall apart at the interview. So do not have inconsistencies, do not have any of that going on, because that will lead the officer to suspect that there may be something amiss with your case and lead to a fraud investigation and a denial. So please take every single step of your process seriously. All right. And then if you're, getting ready for your interview, be sure to do a mock interview. So if you're working with an attorney, the attorney can do a mock interview for you. In our office, we do it for our clients, and we also offer it for people that already have, they filed the application on their own and they just need to be ready for the interview, and they will ask us to do a mock interview for them. We do that as well. So we do that internally. But one thing we're going to start doing is, if you go on my website, we're going to put that up soon where you can just go to the website and see exactly how many, and see what that looks like. If you want to sign up for a mock interview with us, you can actually be able to do that on the website soon, right? It's not up yet, but it's something that we're working on to make that as accessible to people as possible. All right. Next question. Will this affect on a T visa applicant? Will immigration attorneys be able to fight the case in front of the judge in immigration court, or be able to get the client the green card from judge? So it depends on the situation. So if it's a T visa applicant, depending on what the situation is, typically an overstay can end up in immigration court proceedings for just being an overstay. Okay, I always have to say that because it does make a difference. Someone that overstays a visa can end up in immigration court proceedings if they are denied the T visa. All right. So now that is a possibility. Before it wasn't, right? Before I would tell people that's not really something that would happen, but now there's no rules. Okay, so there's rules, but there's really no rules when it comes to that. So the officer, it's kind of left up to the officer to make that decision. And then because a T visa is something that's issued by USCIS, immigration court judges are not able to approve a T visa. So USCIS will need to approve a T visa. But let's say you were approved for a T visa, and then your green card application was denied and you are referred to immigration court. In that case, an immigration attorney can represent you in immigration court, and you can apply for that green card again with an immigration judge. Okay, so if you already have a T visa, you're now applying for a green card, and that green card is denied, and you're referred to court. In that situation, you'll still be able to fight for your green card in immigration court. And when you're in immigration court, there may be other things that you qualify for that the attorney will be able to fight for you on as well. Okay. So, Mohammed, if someone wants to travel to Africa and they have dual citizenship, do you think we need a visa, or the person needs to use their place of birth passport? So you need to travel with your US passport at all times with you, right? There's no passport checks when you're leaving the US, but you just need to have it with you because you're going to want to come back to the US, right? But when you're going into your country of birth, if they require you to use their passport to go into that country, the US government will allow you to do that because you're a dual citizen. So you don't have to get a visa. It is up to you. I have seen people do it both ways, where they're just okay with just getting a visa to the country and traveling with a visa. And then people are okay getting a passport for their country and traveling with that passport. Me personally, I travel with my passport. So I travel with my US passport and my Nigerian passport. I enter Nigeria with my Nigerian passport. I enter the US with my US passport. Okay. So it's all about what the individual feels comfortable with. But all I can tell you is the US law allows you to do that when you're a dual citizen, and I do that as well. Right. So if you have any questions, please put them in the comments. And Shani, I hope I answered your question. All right, so who is most likely going to end up being given a notice to appear for immigration court when their case is denied? Let's talk about that. So when you are doing a marriage-based case, actually any sort of case, if there is any indication of fraud in the case, you are more likely to get a notice to appear than someone that there's no fraud in the case, just that they didn't qualify. Okay. If you have a criminal case, so even if the criminal case does not make you inadmissible, but if it makes you deportable, you can also get a notice to appear. So there's some criminal cases or criminal convictions that make you inadmissible, meaning you're not able to get a green card, you're not able to get citizenship, right? You're inadmissible. And then there's criminal cases that make you deportable, meaning if you do X, Y, and Z, you cannot get you can get deported from the U.S. So inadmissible versus deportable. So I'll give you a quick example. If you violate a restraining order, right? You had a restraining order and you violate the restraining order. That violation of the restraining order makes you deportable, but it does not make you inadmissible. So you can get a green card if you violate a restraining order, but the officer can also choose to give you a notice to appear for immigration court. So I've had clients where we're able to get their removal of conditions done successfully with a violation of a restraining order, but they were still deportable and they were still put in immigration court proceedings because that makes them deportable. So it's really important that if you have any sort of immigration issues, if you have any criminal records, that you are getting an evaluation from an immigration lawyer before you file. Okay, if you have anything that raises red flags in your case, you want to make sure that you are providing sufficient evidence to support your case. All right. So for a marriage-based case, one of the biggest red flags is when the spouses do not live together. Okay. If you do not live together with your spouse, you better have a very, very good reason for it. Okay. You better have a good reason for it. So, and it needs to be documented. All right. So you can't just say, oh, well, we're going to move in together at this point in time. Well, great. If you're moving in together 6 months from now, what documentation, right? What evidence do you have to show USCIS that you are actually making plans to move in together? Because it's not just about saying that you're going to move in together. They want to make sure that you actually plan on moving in together. Because if you don't actually have plans in place and you don't have a good reason, let's say you live in the same city, but you live apart and you don't have a good reason for why you live apart, that's going to raise major red flags in your case. So you want to make sure that you are addressing all of that. Anything that can raise a red flag for you, you want to address it on the front end before you file your application, especially with this new policy of issuing notice to appear in cases that are denied. Okay, so really, really important. This does not mean, I really want to say this does not mean that USCIS is not approving cases, because they are. Okay, they can still approve your case, they can still move forward with applications, but in those situations where there's an issue with the case and they deny the case, they now have even more power and are encouraged more than ever to issue a notice to appear. Okay, so I have to always say this, they've always had the power to issue the notice to appear. It's just now they are really encouraged to issue the notice to appear. Okay. All right, Shani, I thought I answered your question. Yes, it could affect T visa applicants, and immigration court judges do not handle T visa petitions. Those are USCIS specific. However, if the person that filed the T visa, right, if the person that filed the T visa already has the T visa approved, but they end up in immigration court proceedings because their green card application was denied, in that situation, they will be able to fight the green card in front of an immigration judge, because an immigration judge can approve a green card. They cannot approve a T visa. So that's just the difference there. But yes, it will affect all applicants. And it's up to the officer's discretion in some situations. If there's a criminal history, they don't really have a lot of discretion there. But in some situations, they do have discretion. How long is VAWA taking right now? So a VAWA application itself is taking about 3 to 4 years. So that's not the green card, okay? The VAWA application itself is 3 to 4 years. That VAWA has to be approved before USCIS can process the green card. So that's why I always separate the two, because it depends on how long the VAWA itself takes to be approved. And then once that is approved, USCIS can now send that file to the local field office to schedule interview if necessary, or to just go ahead and approve the case. Remember, if you are filing your VAWA application with your green card application, that means there's been 3 to 4 years of you not, updating that form, and things can change a lot in 3 to 4 years. So most of the time, USCIS may just schedule you for an interview to see if there's any changes that they need to update, including if you've changed your name, if you've had any children, all of those things they need to know. So it also would depend on the green card end of things, how long it takes the office to schedule an interview. Those we're seeing about a year after the VAWA is approved, we're seeing those interviews scheduled. Jay, what is your hourly rate? So I work on a flat fee for almost every single case. So it depends on the type of case and what the complexities are in the case. But I work on an hourly, I don't work on an hourly rate, because if I charge people by the hour, no one will be able to afford it, okay? So I charge a flat fee, and I offer financing through a firm, for those that are able to get financing. And then if you're not able to get financing through a firm, sometimes we're able to offer an in-house payment plan as well. All right, Ella, with the new NTA memo, will I-751s be allowed RFE? Ooh, so many questions. 1 second. Will I-751s be allowed an RFE, or is this straight NTA instead of giving you a chance to submit more evidence? So that's another part of the memo, is it's up to the officer whether to issue a request for evidence. It's always been up to the officer to decide whether to issue a request for evidence. But remember, an I-751 can either be issued a request for evidence, or they can schedule you for an interview, okay? So if you are scheduled for an interview, it does not mean there's something wrong with your case. It just means they may need more information from you. Typically what I do with my clients is, if we are scheduled for an interview, we just make sure that we bring more documentation to the interview, especially since the I-751s are taking so long to be adjudicated, so to get to an interview or to get to a request for evidence. So we are going to be seeing more of those cases being scheduled for interviews, right? We are going to be seeing that. So basically, that is your opportunity. That interview is going to, at least for my clients, that's how I'm going to take it from now on, is that is our opportunity to get as much documentation to the officer as possible about the relationship, so that they don't end up denying the case, right? We can basically get a feel of the case from the interview. So yes, they are not required to issue requests for evidence anymore. But I think they're still going to, for the most part, especially if it's something minor, they probably would. And in some situations, they still send a notice of intent to deny for certain cases. Okay. Will lack of a real ID prevent undocumented immigrants from flying from state to state here in the USA? First off, I don't typically recommend for someone that is not documented to be flying state to state anyway, right? So that's not a recommendation I have. Not having a real ID means you need to show another form of ID. So basically, Right now, you can travel with your driver's license. The real ID makes it so that once that becomes, once that deadline reaches, the only way you can travel with your driver's license only is if it's a real ID. Okay, it doesn't mean that you cannot travel with a passport. Okay, it doesn't mean that. It just means that if you just want to travel with your driver's license, that driver's license needs to be a real ID. That's what that means. So it does not prevent you from traveling, right? From flying from state to state. It just means that you're going to need other forms of ID in addition to your driver's license. That's what that means. Now, would I recommend you traveling, flying from state to state? That's a different question. All right. What I recommend it is a different question. But to your question, no, it doesn't prevent someone from flying from state to state. Okay. What if you're denied for work permit and you took biometrics for a U visa with criminal record? Will I be targeted? So it's going to depend. So Samantha, it's going to really depend on what the outcome of those charges are. So it's one thing to be charged with a crime, it's another thing to be convicted of a crime. Okay. And US immigration has specific definitions of what counts as a conviction. So it will depend on whether it counts as a conviction, and that's going to determine whether it becomes a problem. So typically with a U visa, when there's convictions, we typically would include a waiver, right? We would request a waiver for those convictions, especially if they make you inadmissible. We would include a waiver application so that USCIS can still process the U visa and the waiver at the same time. So it's really going to depend on what the outcome of those charges were. Okay, so that's really key there. And then the work permit being denied is not the same thing as a U visa being denied. Okay, so a work permit being denied does not lead to you automatically being put in deportation proceedings. Okay, in this, the way I understand this memo is more of things of substance. So you can have a green card application pending and a work permit application pending at the same time. And if the work permit application is denied, your green card application is still pending. So it's really the ultimate thing that you're applying for. So if you're applying for a U visa, it's really more about, is that U visa denied? Not really if the things that you're applying for because of the U visa is denied. It's about the ultimate thing that you're applying for, which is the U visa. So the work permit being denied should not lead to a notice to appear. But if the U visa is denied because of those charges or convictions, that's when a notice to appear is more likely. Okay. So Moses, hi, I got a 212H waiver approved. Congratulations. For a deportable crime and was able to adjust my status 7 years ago. Can DHS try to remove me if I apply for citizenship for the crime that was waived? So once you have an approved waiver for a specific crime, USCIS does not go back and try to basically reactivate that crime as a means to stop you from getting your citizenship. Okay? Because it was 7 years ago, USCIS for good moral character looks at 5 years. So you had a waiver that was waived. So they're not going to basically, they should not be looking at that because it's already been waived. If it was a new thing that happens, that's different. But because you already have an approved waiver for that specific offense, and if you do not have any other offenses, then typically USCIS would not be able to put you in removal proceedings for something they already waived. Oh, Ella, I'm so glad I was able to. So this is what Ella said. I hope you don't mind. But yeah, I am glad that I was helpful. Because again, there's so much going on. There's so much going on that I am just happy to help the only way I know how. Okay, I only have so many skills, and one of them just happens to be immigration law. So, and that's how I can help in this situation that we're in. So, I'm so glad it was helpful to you. Can ICE or USCIS find an undisclosed court expunged felony conviction? Yes. Yes. So it depends. Let me hold on. It depends. Right? Can they find it? Most likely they can. If it was expunged, it depends, right? It really depends on what it is. And if it's something that actually makes you deportable, then it will make a difference. But typically, when you are applying for anything with USCIS and they ask for criminal history, they do include cases that are, because I know in Massachusetts we can get cases expunged, or like if it's not a pardon. So that's something to really keep in mind. If it's not a pardon where either the governor or the president gave you a full pardon for that crime, it is still considered a conviction and you would still need to disclose it. Okay. So we have a process in Massachusetts where you can basically get a criminal record, a crime taken off your criminal record, so that when an employer searches for it, it doesn't show up. But that does not mean that you don't have to disclose it to USCIS. So you have to disclose it and then let them know that it was expunged, right? So it depends on what you're applying for. If you are actively applying for something to USCIS, depending on what that thing is, it most likely will ask you about criminal history, and you need to disclose all criminal history. And I believe it even mentions that even if it's been expunged, even if you have it taken off your records, you still have to disclose it. And the sad thing about Massachusetts is once they take it off your criminal record and the court process is done, you can't just go to the court and ask for a copy of it if you don't already have a certified copy of it. The only way to then get a certified copy of it to file with USCIS when you're filing an application is to basically reopen the case, get the certified copy, and then have them close it right back up. It's a whole process. So if you are ever in a situation where you want to, close a case or take it off your records, make sure you have a certified copy of it always, because USCIS is always going to want that to know what happened with the case and if it has an immigration effect. So just because it's no longer on your record does not mean it does not have an immigration effect. Okay. Shani, please let me know if you are not hearing me, or if I'm just not answering the question you have, right? Will this affect on a T visa applicant? Yes, this can affect a T visa applicant if the T visa is denied, okay? If the T visa itself is denied, yes, they can end up in immigration court proceedings. Hey, Jay. Oh, thank you so much. Funny enough, Chimamanda is from the same state as me in Nigeria, and my sister actually went a couple days ago to hear her speak in person. So yeah, she's a favorite in my household. Can you go to biometrics with expired passport? Yes, I have clients that do that all the time. If you do not have an unexpired ID, then go with your expired passport. Just make sure it's not make sure it's not a passport from when you were a baby and now you're like 30. Okay, that's the only time that is like you need a different ID. But if If it's within like 5, 10 years that it expired and the picture looks exactly like you, it's fine. We've done it. We've done it. Okay. So don't worry about the passport being expired. You'll still be able to go ahead and do that. Jay, I cannot agree more. I cannot agree more. All right, so I don't see, I think I got to every single question, but please ask me your questions if you have them. This new change is going to affect people. We may not see the effect of it now, but as applications are being processed, as interviews are happening, we're going to see the effects of it more months from now. But this is definitely something major that can change people's lives. Because before it's like, okay, you file a green card application. If it's not approved, it's not approved. And you get to regroup and figure out what's next. Now, with this new process, Sonia, we're talking about the new notice to appear memo that USCIS has that basically says that if a USCIS officer processes a case and they end up denying it, depending on the situation, they can and should put the person in deportation proceedings. So that is something new where they are encouraged to do this. Before, they just had the power to, and most officers don't use it. But now they are basically being encouraged to use it as much as possible. And something to keep in mind too is like, this is not to say that your case will not be approved, right? It's just in my office, what we're doing now is making sure that before we file every single case, we are having conversations with clients, right? And we are making sure they understand the risks and the rewards. And, 9 times out of 10, the rewards of getting your green card and then getting your citizenship is going to outweigh the risk, okay? Especially when you have great evidence of your relationship. If you're filing an I-751, either you're still filing jointly with your spouse and you have you're still building your relationship and you have evidence of that, or you got a divorce and you are filing on your own, you're filing that I-751 on your own, but you have evidence that this relationship was real. We were trying to build a life together. It just did not work out. So cases are still going to be approved. USCIS is going to make it harder, but cases are still going to be approved. It's going to be nerve-wracking. Like I said, we don't know how they're going to really apply this, right? Are they just going to do it across the board? Any case that fits it gets an NTA. We do not know. But what we do know is that when you file your application, before you file your application, you need to make sure that you are looking at all the possibilities, any red flags, and addressing those red flags on the front end. Because now, not only do they have the encouragement to issue the notice to appear, they also can choose to put someone to not issue a request for evidence before denying the case. So you just have to make sure that that initial application you're filing is as strong as possible. All right. Jay, can men be VAWA victims? Yes, absolutely. Men can be victims of abuse, just like women, right? I know VAWA stands for Violence Against Women Act. Yes, that's what it says. However, it applies to anyone that is in a relationship with a U.S. citizen, that is married to a U.S. citizen, and is abused by that U.S. citizen. Okay, so it does not matter if it's a man, a woman, in between. It doesn't matter as long as you meet the requirements. you can apply for it. What about if the T visa applicant was framed in an arrest by the trafficker? Will that still trigger the NTA? Again, it depends on, so that will help with the T visa application. So the key here is whether the T visa is denied, right? If the T visa is not denied, then there's no, it wouldn't trigger an NTA, right? So that's really, and what happened with the court case? Was the person convicted or not? So even if the person was framed and was arrested, were they convicted? Is the conviction that would trigger the NTA? Okay, the conviction triggers the NTA. The denial of the T visa application triggers the NTA. The being framed can help in a T visa case, right, to show the trafficking, but it really is going to depend on the particular situation. I'm waiting for my I-130 to be processed. I have an ID. Can I apply for the real ID without the social security number? I do not believe so. Okay. So I believe that you need a social security number to apply for the real ID. Now, whether you need the real ID or not, it's, it's up for debate, but you would need to wait for your social security number to be issued before you can get that. One thing I will say is if you have a green card application, I know you said an I-130, but if you also have a green card application pending, an I-485, with that application pending, you can apply for a work permit. And if that work permit is approved, you can get a social security number. Okay? So it's just making sure that you are applying for everything that you qualify for at once and not doing things in piecemeal. Okay. Right. So our 601 waiver is still getting approved. Yes. So applications are still being approved. Okay. Applications are still being approved. Cases are still being processed. It may slow down if they keep firing people, right? If they keep firing federal employees, and if USCIS ends up being on the list of people that are being fired, things are going to slow down. But until they do, they're still processing applications. They're still approving applications. Okay. We recently got an I-751 approved last week with no interview. Okay, an I-751 that was a waiver, right? Not even filed jointly. It was a waiver-based I-751, removal of conditions, approved without an interview. So things are still moving. Like what you file is still being processed. We're not seeing the full effects of things yet. So things are still moving. If USCIS loses their employees, then we're going to see a huge slowdown in cases being processed. But will the cases be processed? Yes. Okay. And if you qualify for it, will you be approved? Yes. How long after USCIS receives RFE to be adjudicated? It depends. So it can, once they have to issue an RFE, it kind of throws off the whole timeline of a case. So it really depends. I have one that's pending since January. So it a 601 that's been pending since January. So it really depends. It really depends on what's being processed, what their backlog looks like. That's another thing. Because when it comes to those, you have to, it depends on the backlog. Because if you're applying for, let's say you're applying for a green card and you need a 601 waiver, if the 601 waiver is taking a year to a year and a half to be processed, right, it's going to throw off your green card application because the green card application cannot be approved without the 601 waiver being approved. So it really just depends. Can a T visa Can a T visa applicant have a waiver for criminal history in the past and false claim to be a U.S. citizen under duress? So it depends. So can they apply for it? Sure. Well, there's a difference between being able to apply for something and it being approved. So it's going to depend on the facts of each case. But is it possible to apply for it? Yes. It's just going to depend on the details in order for the officer to decide whether to approve it or not. Moses, even though I got a waiver, 212H deportable crime, but 601 says inadmissible, and the new memo affects my decision. Okay, so it's two different things, right? When it's waived, it's waived. Okay, when it's waived, it's waived. USCIS cannot come back and use the same crime again to make the person not. So they approved the green card, right? You did the 212 and they approved the green card. In order to approve the green card, you need to be admissible. So, yeah. Again, without knowing what the crime is and all of that, typically when they waive a crime, they waive it. All right. In the law, USCIS have to give you a notice of intent to deny before a decision. It depends on the case. So not every single case requires a notice of intent to deny. So for example, an I-130 typically requires a notice of intent to deny before it's denied. A citizenship application typically requires a notice of intent to deny before it is denied. A green card application, not so much, right? Because a green card application can be denied for the I-130 not being approved. So typically, if you're filing an I-130 and an I-485, the notice of intent to deny is coming for the I-130, not typically the green card application. So it's just going to depend on the case. So again, the purpose of me telling you all of this is not for you to get scared and not file your applications. I want to make that as clear as possible. That is not the purpose of me telling you this. The purpose of me telling you all of this is so that before you file your applications, you are taking the necessary steps to know exactly what are the things that can affect my case and what can I do today, right? What can I do today to make sure that I have the documentation to overcome those things, right? So you have to now take proactive steps when you're preparing your case. We do that for our clients, but I want to make sure that you understand you need to take those proactive steps. Every single step that you take in your case, you need to make sure that you're meeting every single requirement and you're not doing things unintentionally that will affect your case. Okay. Like I said earlier, we are going to start. Well, we're going to put on our website soon. We don't have it up yet, but soon we'll have a link where you can actually book a mock interview with me. And part of the mock interview is reviewing your documents, reviewing what you filed, and asking you questions as if I'm the officer. Okay. I'm not your attorney that day. I am an immigration officer looking at what you filed and asking you questions and being tough on you because I want you to win. Okay. So that's going to be available soon where you can just schedule a mock interview with me and I will be able to actually look at your case and ask you questions as if I'm the officer. And then afterwards we'll debrief and, give you my thoughts on how things went and what I think you can improve on. So watch out for that soon. Once the link is up, I will probably put it in the description of all the videos moving forward so that you can do that. But yeah, that is something new that we're working on the back end. Have you ever seen an asylum decision transferred to immigration court and a lawyer appeals the decision with USCIS? So when an asylum is referred to immigration court, right? So you had the asylum interview. The officer did not feel that there was enough there to approve the case. Their only recourse is to refer it to immigration court. So they're not denying the asylum, they're just going to refer it to immigration court, and the judge will have the final say. So you get to present your case again in front of the judge. Have I seen that referral be appealed? No, because that is the process that's given, right? When it's referred, that's your chance to continue fighting the case. So the referral is not an appealable thing. Okay. How soon can I file my marriage-based green card after marriage? So it depends on you, right? I tell people I want to see evidence of your relationship before we file, right? We need to see strong evidence of the relationship, especially with the new, memo out now. You really want to make sure that you have strong evidence of your relationship on the front end when you're filing, and then continue building that evidence as you're waiting for an interview, or you may get a request for evidence. But while you're waiting for that, you want to make sure that you're gathering those documents. So it really depends on the evidence that you already have. If you tell me that you don't have anything, then wait till you have something. Okay. And by anything, I mean pictures, right? Do you two have pictures together? Have you hung out with each other's families? Things like that. Do you have you taken trips together? Do you have text messages, call logs, things like that, right? Because if you just got married, it's not going to be a lot of joint things unless you lived together before you got married. Then you may have bills in both your names. You may have a lease in both your names. But if you don't have that yet, you can use your dating relationship to show how you got to the marriage, right? So if your U.S. spouse is, okay, so U.S. spouse is 48 and you're 27, is this a red flag? Yes. So a red flag does not mean an automatic denial. It just means you need to show more of your relationship. That's really what it means, okay? So when I say you need to know what your red flags are in the front end, you need to know what it is so that you can prepare for it. Because if you know what the red flags are and USCIS starts talking about, oh, well, why, the age difference and all of that, you're not surprised, one, right? The worst thing is going to an interview and being asked questions that you're not prepared for. So one, you're not surprised by the questions, and two, you are already prepared on how to respond to that, okay? You already know that you need more evidence of your relationship, more evidence of you two living together, building a life together, showing the world that you two are together. That is going to overcome a red flag, right? But it's really important to know that it's a red flag and not automatically think that red flag means a denial. Okay, red flag does not always mean a denial. It just means you're going to need to present more evidence and be ready to fight for your case, right? Be ready for that interview. Be prepared to answer questions about each other, your spouse, your family, everything, your life together. So knowing your red flags, right? Knowing your red flags is a good thing when it comes to immigration cases. Knowing that you have red flags in your case, knowing that USCIS may have issues with X, Y, and Z, that is a good thing, because that means you can prepare for it. You can include evidence to support you, right? To support your position. And you're not going into an interview being blindsided by USCIS. All right. So in my next video, I'm going to be the one coming out on Tuesday. I'm going to be going over what you need to be including, like your application recipe. I did a video on that a couple months ago, but I want to kind of talk about it again with the new things in mind, on what that recipe needs to look like, your application recipe, and the red flags that you need to be aware of on the front end so that you don't have to worry about, once you know your red flags, you know what to prepare for. So that we're going to talk about that in the next video as well. So if you have questions, those populations, that's good. Yep. But, just let me know if you have any specific questions or topics you want me to cover in a future video. So it's really important that we, continue the conversation, and I'm giving you information that's actually helpful to you. So when do I come live? I'm usually live on Fridays at 12 p.m. Eastern Standard. Okay? I try to take like 1 month off, 1 day off a month. Wow. I try to take one Friday off a month when it comes to the lives, but typically 12 p.m. Eastern on Fridays. I am here either teaching something, giving you updates, or just answering your questions. Okay. I received a request for evidence for my I-751 case. I sent all the evidence I have. Well, it depends. So sometimes you think you've sent all the evidence you have, but your evidence may not make sense to the officer, right? It depends on what the request for evidence is asking for, right? And sometimes there's evidence that you're not even thinking about that can be used to help support the case. So it really depends on what that request for evidence is asking you. So really important that you don't, assume that, that you've included all the evidence that you possibly can. You really need to look at the specific request for evidence. What are they asking for? What is the issue that they are saying that the officer is looking at? Okay? Because that's what's going to make all the difference. You need to speak the officer's language. You need to understand why they even send the request for evidence before you start responding. All right? Because I have seen cases where people will go and respond to a request for evidence and send the thing that is not being asked for. Okay? They leave the important things out of the response, and then the case gets denied. So you want to make sure that when you get the request for evidence, you need to read it and make sure you understand exactly what the officer is asking for and why they're asking for it. Okay? You need to understand why they're asking for it. That your response is as complete as possible, so that the officer has everything they need in order to actually decide your case in your favor. Okay, that's the goal. That's the goal of all of this, is for the officer to decide the case in your favor. So you need to know what the officer wants in order to do that. All right. So as always, if you would like to schedule a strategy session with me, go to my website, lilylegal.com, and click on contact us, and you will be able to pick a date and time that works best for you for us to chat about your situation and see what your options are and how I can best assist you, if I can assist you. I will be seeing y'all next Friday. We'll have more chats. If anything comes up in the meantime, just know I will be talking about it on Friday. And if there's, like I said, if there's any specific topic you want me to cover, either on a live or on my Tuesday videos, which is more of like a sit down where I, talk about a specific topic, please feel free to DM me if you're, Instagram, Facebook, TikTok, all of it. Feel free to DM me. I'm really legal on almost everything. Or just put it in the comments. Cover this topic, please. And I will be more than happy to do a video just talking about that. All right. Thank you all so much for joining me. I truly appreciate you all. Stay safe out there, and I'll see you next week. Bye.